Good morning, I'm Gary DeWaal, and this is Bridging the Week for September 30th through October 4th, and today is October 7th, 2019. Last week marked the end of the Commodity Futures Trading Commission's fiscal year on September 30th. In response, the Commission published a large number of last-minute enforcement settlements right before, on, and right after fiscal year end. There were too many cases for me to discuss them individually here, but they involved allegations of spoofing, failure to supervise, the illicit misappropriation of confidential client information for non-authorized purposes, reporting violations, and failure to provide the CFTC with non-misleading information when asked. The CFTC also brought two enforcement actions against interdealer brokers in conjunction with parallel New York Attorney General allegations for fraud in connection with emerging markets foreign exchange options. The firms in aggregate agreed to pay fines totaling $37.5 million to both regulators to resolve all four matters. Overall, CFTC fines were high, but the Commission claimed it gave credit for self-reporting violations and cooperation. Two matters that struck out for me. In one case, the CFTC brought an action against an individual for misleading multiple future commission merchants regarding the ultimate owner and controller of corporate entity accounts. He did this because one company he ultimately controlled lost $2.1 million at one FCM, and he did not want the other FCMs to know about this when he opened up companies with them in other names. Unfortunately, the company sustained losses at two of the other FCMs also. Additionally, in three of the settled CFTC enforcement actions, the CFTC expressly noted the role of the compliance department or individual compliance officers in contributing to the registered firm's purported rule breaches. Bottom line, the compliance personnel were allegedly not doing their job, implied the Commission, although no individual charges were brought against the individuals. Wow, where could this be leading? I give a lot and probably too many details regarding many of these cases on the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. Last week, the U.S. Federal Court of Appeals for the Seventh Circuit made public all relevant documents, including court transcripts, related to the alleged breach by the CFTC of the gag order in its settlement with Kraft Foods and Mondelez Global in August. The CFTC is seeking a mandamus order from the appeals court to prevent the district court from conducting an evidentiary hearing to determine whether the Commission should be held in contempt and subject to sanctions for issuing a press release, a separate statement, and concurring statements by two commissioners at the time it released the settlement order. It turns out the CFTC claims the district court is proposing to conduct a criminal inquisition, which it claims is prohibited by law. Criminal matters should be referred to prosecutors, says the Commission. Separately, defendants say a contempt finding is warranted because the CFTC purposely violated the gag order. They offer as evidence a conversation with the director of the Division of Enforcement they had prior to the Commission signing off on the settlement order, where the director asked for the gag order to be removed from the proposed order at the request of two unnamed commissioners. They refused this, defendants' counsel say. Moreover, the director never indicated it was the position of the CFTC that commissioners don't act on behalf of the Commission. We will see where all this goes. And finally, Block One, a technology company, settled for $24 million a Securities and Exchange enforcement action claiming its 2017 through 2018 initial coin offering constituted an unregistered and thus prohibited securities offering to U.S. persons. However, Block One was not required to provide restitution or register the relevant digital tokens as part of the settlement and was expressly authorized to conduct private offerings going forward. This is a very different outcome for Block One than for other recent sponsors of non-fraudulent ICOs. I've got more on this at the article version of the blog at www.bridgingtheweek.com. You know that. Check it out. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a nice week, and until the next edition of Bridging the Week, ciao.